Hello everyone. Welcome to the first presentation in this series on Introduction to Laws. This presentation deals with the scope and importance of international law. International law, as we have already seen, is the law governing nations. It is classified under two heads: public international law and private international law. Public international law deals with rules governing the relations of states with each other. Private international law deals with rules which help in resolving conflicts between two individuals belonging to different nations. It is also called conflict of laws or choice of laws. Rules of public international law may be universal, wherein it binds all the nations, or it may be only regional, where it binds only the states which are members of that regional group, like SAARC, OPEC, etc. International law is different from international committee, which consists of merely courtesies followed by different nations. It is also different from international morality, which is a system of values which are recognized as necessary for maintaining good relations with the neighboring states. The subject of international law would be the state. So, international law basically consists of agreements entered into between states, which are hence binding on the states. Now, what is a state? What are its characteristics? A state, which is a unit in international law, should possess the following characteristics. It should have a defined territory. It must consist of a permanent population. It must be governed by a coherent political structure, that is, it should have a government in any form, and it must be capable of entering into relation with other states, that is, it should possess independence and sovereignty. We have already seen that in order to maintain order and to ensure peaceful coexistence of human beings, rules regulating the various aspects of human life are promulgated and enforced by the state. Without these rules, the population there would be under continuous threat to their life, liberty, and property, and hence they will not be able to engage in any other productive activity. In the same manner, in order for the states to progress, they must be allowed to coexist peacefully with the neighboring states. Factors like continuous intervention in the internal affairs of the state, threat of invasion on its territory, exploitation of its manpower or natural resources due to inadequate economic relationships, and lack of concern for human rights cut across state borders and create tension in the world politics, thereby hindering the progress or development of the nation. Now, states must be governed by law in order to seek and achieve certain goals, which may be economic well being, survival and security, or ideological advancement. Therefore, states came together and succeeded in creating a system for themselves for protecting certain values, which included the non intervention in internal affairs of a state, respect for its territorial integrity, non use of force, and equality of status in international bodies, which evolved after world wars. In the day to day affairs of international life, states depend on each other, and hence thousands of agreements are made and many customs are followed for exchange of natural resources, manpower, technology, etc., and for creating a market for finished products. In this frenzied interplay of the world affairs, there has to be some rules and regulations within which the game can be played, and the international law satisfies this requirement. International law becomes a necessity for states because it introduces an element of stability and predictability into the situation. When the countries are involved in disagreements or disputes, it is handy to have recourse to the rules of international law. Thus, international law can be defined as aggregate of rules governing relation between states which are expressed by the ruling class of the states. These rules are designed to safeguard their peaceful coexistence and help the countries in mutual cooperation, and whenever there is a conflict, to resolve it amicably. These rules are defended in case of need by coercion applied by states individually or collectively. International law is therefore the law created by states and are obeyed or disobeyed by states. International law is formulated by international agreements and customary rules. International agreements bind the signatories, that is, parties to the agreement, and customary rules are practices which have evolved over a period of time through states recognizing and following them, and hence these have to be complied with. As the complexity of the modern societies have multiplied, international law has been developing in many directions. Its scope has become immense. From mere concern with preservation of peace, it spread to almost all the aspects of contemporary international life, like the regulation of space exploration, division of ocean floor, and maintenance of international financial systems. It expanded horizontally to embrace new states and extended to include individuals, groups, and international organizations within its scope. It moved into new fields covering international trade, environment protection, outer space exploration, and exploitation of resources of oceans and deep sea beds. International law became more sophisticated with the addition of regional organizations like Organization of African Union, Organization of American States, etc., which evolved rules that bind the member states. With upsurge in difficulties faced and increasing the number of states in the system, the range of topics covered by international law expanded. Provisions relating to the bureaucracy of international institutions, international labor standards, health regulations, international economic law, conservation of environment, human rights, and communication control are also included within the scope of the subject. As these have a direct bearing on the making, executing, and interpreting of national laws on the above said aspects, it is necessary to have a broad idea about certain vital aspects of international law, and hence this is a compulsory paper in law courses of all universities. Coming to the second class of international law, the private international law, it consists of rules governing cases having foreign element. It applies to individuals and not to states. Here, the conflict is not between different states but between citizens belonging to different states. Hence, it is also called conflict of laws or choice of laws because it concerns with the determination of which nation's law will govern a transnational matter. There has been a considerable increase in the international migratory flows and free movement of people, services, goods, and capital across various jurisdictions due to liberalization and globalization. Because several legal systems would be involved when a dispute arose between two individuals or parties belonging to different legal systems, it becomes necessary to clarify the rights, privileges, and entitlements of such parties. Private international law comes into operation whenever a claim containing a foreign element is brought before a court. For example, let us say the two Englishmen enter into a contract in France to sell goods situated in France. Here, when the validity of the contract is questioned in an English court, according to the rules of private international law, the court has to apply the French law to decide the validity of the contract. The recognition of foreign law in a case containing a foreign element is necessary because otherwise it may result in injustice to one of the parties, and in order for the court to act in a rational manner, it has to take into account the relevant foreign law. Private international law deals with a variety of topics which include international contracts, torts, family matters like marriage, divorce, adoption, etc., property matters, and recognition and enforcement of foreign judgments. Private international law deals with with a wide range of aspects which include answers to questions like which court has jurisdiction to hear the case, which country's law should be applied to resolve a particular dispute, whether judgment made in a foreign court can be recognized and enforced in different jurisdictions. As each country is empowered to make its own rules, scope of private international law varies from country to country. Private international law not only includes rules made by the national authorities, but also includes rules agreed between different states in the form of bilateral agreements and multilateral treaties. Multilateral treaties provide for uniform application of rules across many jurisdictions. These are developed and promoted by international organizations like the Hague Conference on Private International Law, the International Institute for Unification of Private Law, and the European Union. Though public international law is a compulsory paper in law courses, this subject, that is the private international law, is offered only as an optional paper in LLB. However, it is taught in great detail in LLM, especially in the branch of international law. Thank you.